Okay, moving on. Let's talk about negotiation and dispute resolution systems. Certainly there's something to be said about litigation, but there's also something to be said about negotiation. And being able to negotiate, trying to come up with a resolution on your own without the help of the court is certainly a good thing. Along with that is alternate dispute resolution, which is going to be your arbitration and your mediation. Certainly I really enjoy negotiating. I think that going to the negotiation table and trying to get the best price for a product you can is good. Certainly, trying to resolve disputes it's cost effective if you can negotiate. Believe it or not, the book points out that 95% or more lawsuits are actually settled prior to completion of the litigation process, and this has a lot to do with discovery and money and everything else, because again, once everybody understands what's going on in a lawsuit, two reasonable, prudent lawyers can get together and come up with a settlement that's reasonable for both sides. Certainly I tell my clients, whenever you have an opportunity to settle it, do it, because you can control how things are settled, whereas when you go in before the judge can do whatever they want. I mean, you can go into court with a slam dunk case and still lose, but keep in mind you can also go into court with a horrible case and still come out smelling like roses. It all depends. Now, conflict and disputes. Now, conflict exists whenever there are two or more points of view. So certainly, if Dr. Peter Venkman and I've forgotten his name, Whiplash, brain fart, if they have a different point of view, like, oh, I think the Baptist church is the best church out there. No, I think the Methodist church. I know it's not a big deal, but come on. Anyway, they have a conflict, all right? Now, dispute arises when one party makes a claim that the other party denies. I think you hit me. No, I didn't. Okay? So conflict, 2 points of view. Dispute, one person claims something, the other one denies it. Okay? So when we're talking about, let's talk about it with like a real case. We have a 1968 Chevy Camaro. Okay? It is clearly going down the road. Okay? It rear ends Dr. Peter Venkman. Okay? The traffic light was green. No, it was red. Okay? He says it was green. He says it wasn't. Now, styles and methods of negotiation. Negotiation is a process used to persuade or coerce someone to do what you want them to do. All right? Certainly, with this personal injury matter, Dr. Peter Venkman, through the process of negotiation, is going to try to get Whiplash to pay for his medical bills and the damage to his 1968 Chevy Camaro. Nice car. I prefer the 69, but the 68 is okay. Now, is going to try to get him to pay all of his medical damages, all of his special damages, and his attorney's fees, yada, yada, yada. Okay? He's going to say no. But he's going to say, hey, look, I can go to litigation. I can sue you for $10 million and win. Ooh, maybe I will settle. Okay? It depends. It's a process of negotiating. You gather up all of your information, you send it to the other side, and you try to come up with a resolution. Okay? Now, positional, parties state their opinions, begins competitively, and involves give and take. And that's what you're going to see in a lot of negotiation. You're going to see people, stating their different points of view and trying to come to a resolution, right? And it is a competitive type of thing. That's probably why I enjoy it. I know whenever I go and buy vehicles, that's always a lot of fun, or even when I sell vehicles. Believe it, it's amazing the things that lawyers do. But I really enjoy that negotiating process. I enjoy to watch the other side give their tells and say, oh, this is the best price in the world. Yeah, bull. Do your homework before you go and do that, before you start the negotiation process, and you'll do a little bit better, because it is competitive. Principled, several different things to this. Communication. Clear communication between the parties may assist them in becoming joint problem solvers. Folks, keep in mind that whenever you are negotiating, debating, arguing, whatever, As long as you stay within the realm of what the issue is, you're fine. You know, you hurt my back when you hit me. Well, I still think the light was green. You're an idiot. Okay, negotiation's over. Discussion's over. Okay, Dr. Peter Venkman went off the issue. The issue is not whether or not Whiplash is an idiot. The issue is whether or not that light was green. Relationship. Now this is talking about from a business perspective. Certainly, what you want to be able to do is, especially in a business relationship, determine whether or not it would be beneficial for the two parties to continue on in their business relationship. I'm actually working on a case dealing with computer websites. And the way I started the negotiation process was to try to convince the parties that it would be beneficial for both of them to stay together. However, there was so much animosity between the two that it just didn't work out, so we've had to go to litigation. Interests. What are your interests in this negotiation? What do you want? You know, in a personal injury case, you know, you want your medical damages paid, you want your property damage paid. In a purchase and sale of a vehicle, you know, you want the best price for the vehicle. The dealer wants to get the highest price possible. You know, in the case of, you know, internet information, you want to, you know, get out whatever dollars you invested. But options, you need to brainstorm options. You know, what are other options here? Believe it or not, folks, when you get emotionally involved, it's very difficult to make decisions. However, if you have an attorney, that attorney can look at all of the options and try to advise the client. Legitimacy, application of accepted standards to the topic negotiated. You know, how reasonable are the standards associated with this particular problem? Alternatives, all right? What are the outcomes that are possible without the agreement of the other party? You know, what could happen as a result of not coming to agreement? And again, I have to tell my clients that from time to time. And sometimes I do that to tell the client, listen, you know, your best alternative here may be to go ahead and settle this matter, because if you go to litigation, there's no guarantee that you'll get what's on the table. Commitment, conclude by making realistic commitments. And folks, that's important. All right? Now, you want to leave the negotiating table with an idea of what's going to go on and try to come up with a resolution that is clear, concise, and is beneficial for, well, obviously for me, I want it for my client, but in reality, you want all parties to walk away feeling like they've been successful.